Welcome everyone to the video on healthcare, ethics and the law. We will be talking about a lot of ethical issues and the law where they collide. Remember, healthcare and the purpose of medicine. What are we looking at it? First and foremost, the healthcare is to be defined as a service provided to people or communities by agents. When I say agents, is the medical practitioner of the health services and professions for the purpose of promoting, maintaining, monitoring, and restoring health. The medical standard of care is composed of all treatment options that can potentially cure, stabilize an illness, state of health, and of alleviate pain and distress. The purpose of medicines are to offer this medical benefits to those in needs, to try to achieve these medical benefits as humanly as possible, if I may say so. The medical standard of care and the purpose of medicine holds true throughout our college collective global history across religious and cultural belief. The doctor-patient relationship is central to the practice of healthcare and is essential for the delivery of high-quality healthcare in the diagnosis and treatment of diseases. The doctor-patient relationship forms one of the foundations of the contemporary medical ethics as the case needs to be. So, we're talking about ethics. Ethics is a standard of behavior based on moral values that are influenced by family, culture, and society. In medicine, ethical principles have long formed the core nature of the professionalism and a key to the fiduciary nature of the physician patient relationship. Example, the premium non nocere. Many different ethical theories exist, though none will provide the answers to every single dilemma that arises in clinical or research practices every now and then. So, what are we looking into it? We are talking about the ethical principle, as in the common ethical grounds of all the theories that consist of beneficence, which are nothing but helping to cure, stabilize illness, alleviate pain and distress thereby. What is non-maleficence? Preventing harm to do no harm. Autonomy, self-determination, independence, liberty, rights, individual choice, freedom of will, justice, fairness, equity. This is what we are talking as far as ethical principle. Beneficence, non-maleficence, autonomy, and justice. Other core ethical norms in healthcare are veracity in terms of telling the truth, informed consent, respect for autonomy. People don't doesn't do it. Privacy, a person's rights to remain private, to not disclose information, confidentiality, not sharing the private information, probably even on need to know basis. Fidelity, loyalty, maintaining the duty to care for all, no matter who they are or what they may have done. Fiduciary, trust, advocacy, confidence in the physician patient relationship, that its sole purpose is to help the person dealing with the illness thereby. Law. A law is a rule of conduct or actions and is enacted by government to maintain orders and public safety. In healthcare, law provides a crucial framework for professional medical practices by mandating legal standards of practices to protect both physicians and patients by outlining duties and responsibilities, perhaps the rights also. So that is what law is. Law is a rule of conduct or action that is enacted by government to maintain orders and public safety. In healthcare, it is a crucial framework for the professional medical practice to mandate legal standards. That is what we are looking around here. Now I'll talk about the importance of the health laws. It defines the key legal principles, the rights within the practice of medicine, makes the practice of medicine consistent and transparent with regards to the physician fiduciaries duty towards patient, helps refine the medical standard of care by examining it in the light of changing societal values, clarifies how resources will be used in a different varieties of ways that permits public discussion, that promote clarities and probably improves upon the justice. If well written, health law brings in the best in the medicine. Allow me to discuss the civil code, the medical treatment, what we go around it. Who can treat patient is clarified, but is not scientifically justified. Consent is described and made compulsory in any invasive procedures, with exception of emergency, but there is no provisions from informed consent. Punishment in case of death of patient death of a patient due to negligence is fine or some years of imprisonment or even both per se. The homicide investigation, in situation of suicide or even homicide, there should be an autopsy in a government hospital by the government employee, medical doctor. No clear cut guidelines and protocol to follow. Physical assault, grievous hurt, conditions are listed where you have broken some bones wrongly without following a systematic and scientific approach. Punishment is in assault is decided by the physical measure of bruises that comes around it. If it is just a bruises, probably lesser punishment. But if things have broken, your bones have been broken, it gets severe. Now talking about sexual offenses, no provisions with respect to medical examination of the victim and abused. Also, no developed examination and reporting guidelines exist. Criminal responsibilities and insanity. An accused will be exempt from punishment if the commission of the act is without the knowledge about the nature and consequences of the act, because there is a disease of the mind or he is cognitively, mentally unstable. No further description of how to evaluate the accused. Neither should we conduct such an evaluation, nor how such a findings could be challenged. See Consumer Protection Act. Compensation in cases of medical negligencies needs to be understood time and again. Purpose of this law is to not directly relate it with the case in field of professional services. Selling or supplying substandard medical goods, services is likely to harm patients' health makes a doctor or health institution to be liable. Tell me, who is to be liable? The doctor or the health institutions? Remember, prohibits manhandling, vandalism in health institution, fine or reasonable compensation as per the court discretions. It obliges local administrations and government to arrange immediate security if demanded by the health worker or institution thereby. Legal standard of care, degree of skill, proficiency, knowledge, care, prudence, ordinarily possessed and employed by members in good standing within a profession. To test whether the standards of care has been met, one must determine what a reasonable, prudent practitioner would have done in a similar circumstances. The legal standard of care is squarely based on the medical issues of care. Now, the medical standards of care to be considered as a prescriptive option, a treatment must have some potential to provide medical benefit. While any prescription has risk and side effect, it must not cause harm to a greater extent. Prescription that may offer medical benefits are presented to capable patient or a substitute decision maker to consent to their according to their values, wishes, and beliefs per se. It if harms outweigh benefits, remember negative consequences are more than the positive consequences. The context of the patient's state of health, such a prescription would fall outside the medical standard of care and it is not a treatment reflected in the national healthcare policies or international healthcare policy. So, what does this mean for the managers of hospitals? The overall objective is to provide good healthcare that is quality oriented and sensitive towards the needs of the individual patients. Manager needs to prepare, develop policies and procedures, provide comprehensive health care, that is care that has potential to provide medical benefit either to the specialist or referral based on the patient requirement. Achieve and maintain the medical standard of care throughout the hospitals or the healthcare institution, whether such care is acute, resuscitative, chronic, complex, or EOL. Ensure services is responsive to the nature requirement, to the needs of the people. Now we come to the last phase of this particular video is all about ethical, all about legal aspects of hospital management. Patient safety and quality improvement. Managers should work across hospital to develop standardized policies and procedures that mandates informed consent, always informing the patient and getting consent from their own words, or at least from the families of the patient, the kith and kin of the patient. Reinforce the physician fiduciary duties to patient through medical standards of care. Medical record keeping, detailed and accurate patient area record. documents of informed consent, documentation of the treatment offered, and decision making with the patients and the patient parties thereby, confidentiality, private policies, and procedures that are very clearly stated and publicly available. Third party information, disclosure policies, procedures that are transparent and public across hospitals throughout the Nepal. What are we looking as far as healthcare worker safety is concerned? Managers should work across hospital to develop standardized policies, standardized procedures to ensure individual patient and healthcare providers safety. Zero, absolute zero tolerance for the verbal or physical threat policy. No bullying should be accepted of any kind. Safe working environment, appropriate safety procedures in hospital wards, laboratories to be maintained for the health and the security of its staff. To conclude, legal aspects of medical practices is incredibly underdeveloped and completely not existent in or developing countries. Some provisions with respect to the criminal investigations are irrelevant, outdated, and unscientific. Ethical guidelines for all levels of medical professionals are currently probably inadequate and needs to be developed urgently. There should be a proper training every now and then. Annually, every medical practitioner should undergo some sort of training. Existing ethical and legal provision must be reviewed, updated to optimal international standards in medical profession. There must be separate attention to be provided to mental health act incorporated to the medical laws and ethics needs to occur in medical education. Leadership from hospital management can make the real difference in improving the legal and ethical standards of practice in hospital. With these words, I come to an end of this video. Thank you for watching it.